And I'm pleased now to introduce to you the first speaker, Rachel Brett. She is based in Geneva, Switzerland, and is the UN representative at the UN of the War Resisters International. And it's also part of the WRI's Rise to Refuse to Kill Committee. She retired from Quaker UN office as their Human Rights and Refugees representative after over 20 years, during which she helped to gain recognition of conscientious objection to military service as a human right. She serves on the War Resisters International Right to Refuse to Kill Committee and gives an overview of conscientious objection in international law. We thank her for being here, and I give the floor to Rachel. Thank you, Rachel.
Thank you, Zaira. Let me see if I can actually work the technology. Can you actually see my screen presentation? Would someone? Yes, thank you. Excellent. So I was asked to give an introduction to strategic litigation. And that's what I plan to do, first of all, with the sort of framework and then giving one specific example. So first question, what is strategic? Why is it not moving on? That's an interesting question. Yes, what is strategic litigation? The simple thing is that it's really just the use of the court or any kind of a judicial process to create or be part of a strategy to create systemic change. So it's not just about an individual case and trying to address that individual case or situation, but it is about that systemic change process. It can be local, national, regional, or international. But as I say, the quality that is so important is that it is this fact that it is intended to make a big change, not just resolve a particular case. So it is part of a strategy. It's not something that is a one-off activity all on its own. I mean, obviously you can do it like that, but then it loses most of its point as strategic litigation. But it's also important to recognize that sometimes this is not a useful route. It may not be available at all. For example, the state may not be a party to the relevant convention or complaints procedure, or you may not be able to seize the court with the case for whatever reasons, or in fact, it may not be useful or appropriate. And when considering strategic litigation, the factors to consider are, first of all, obviously, is this a legal issue or can it be framed as one? Secondly, is there a court or a body where it can be raised? Are the courts independent and well regarded? This can be a very important consideration because would a court decision address the problem, have a widespread effect, or add significantly to the overall strategy? If the answer to that is no, then you're probably not thinking that strategic litigation, or you shouldn't be thinking that strategic litigation is the way to go. And then finally, and very important again, what would be the consequences of failure? If the decision goes against you, how damaging could this be? Or is this something that would not be such a big problem that you couldn't have another go or change your strategy? The next thing to think about is the role of organizations, and that can be WRI, for example, it can be a national NGO, or it can be different kinds of groups. And depending on the nature of the organization and of the judicial process that you're planning to use, your role can be to bring the case itself, to support and or guide others in bringing the case, or as what is called a third party intervener, an amicus curiae, a friend of the court. But when in any of those roles, it is really important to have the right case, that it is well presented, that the court and or the judges have all the information and the legal arguments to help and encourage them to make the right decision. But even if all that works and you get the right decision, it's still important to do follow-up, because the court decision on itself may not get you as far as you would like. Because again, in most instances, the court itself considers that it is addressing a specific case. Sometimes it can be larger depending on the court, but and so you then need to make sure that that information gets out, that it is picked up by others in whatever form, whether it's other lawyers, other courts, other activists, in the media, to ensure that you get the maximum benefit from a good judgment. So let me give you one specific example, which is indeed how we got the recognition under international law of conscientious objection to military service as a human right. And not surprisingly, there was a long process behind this, but I'm not going to go into that because you do have the next webinar, which is going to be on the UN processes. So just to be aware that I'm only giving you the focus on the strategic litigation part in order to establish that international principle. So what we needed was an individual case to the UN Human Rights Committee, which is the body that oversees the International Covenant on Civil and Political Rights. To maximize our chance of success, the case that we needed had to be really clear and really strong. In other words, it needed a country which had an active military conscription, so this was not theoretical, that there was no provision for conscientious objection, so we weren't going to get into debates about what kind of alternative service or whether the alternative service could be longer than the military service or any of those kinds of issues. And we needed a conscientious objector, or more than one, who was a pacifist, not a selective or a political objector. Again, so there was no debate that this was a based purely on religion or belief, not on political opinion or other factors, and preferably on really readily understandable grounds, and whose credibility was not in doubt. And finally, who had suffered a significant penalty for their objection. So again, the decision-making body, the Human Rights Committee, would have to consider that this was a serious issue. It wasn't trivial. And so, as I say, with that sort of group of criteria, we knew that the committee would have to address the fundamental issue of whether the covenant requires a state to accommodate conscientious objectors. In 2004, we got the perfect case from the Republic of Korea. And I don't know whether they're going to tell you anything about their side of the story, but they had gone through a long process whereby this was 2 Jehovah's Witnesses who had been imprisoned for their refusal to undertake military service, whose cases had gone through all the Korean courts, right to the Supreme and Constitutional Courts. And we worked with them and their lawyers to submit the case to the Human Rights Committee, making sure that we had all the information in the format the committee liked it, that we made clear that all the procedural requirements had been met, etc. And as I say, after we'd done a lot of work with the Human Rights Committee itself. And 2 years later, indeed, the committee adopted its groundbreaking decision that the government was required to provide for conscientious objectors as part of the right to freedom of thought, conscience, and religion. But I want to give you the next little bit as well, because this is where I said the follow-up is also important. Unfortunately, this did not immediately resolve the issue in the Republic of Korea, even for the individuals concerned, if I remember rightly. But it did play an important role, and we'll hear some more about what's happened in Korea since then. But one of the significant things that it was able to be used for was in Colombia, for example. Now, why would a decision about South Korea be applicable in Colombia? Because in the Colombian constitution, and Mariceli can probably tell you more about this if she would like to, there is a provision that ratified human rights treaties have effect in their domestic law. And previously to this decision, the Constitutional Court had said that this conscientious objection wasn't protected under the Constitution. And so this enabled the Colombian NGOs, again with support from the internationals, including WRI, to go back to the Constitutional Court. And indeed, it changed its position on the basis that this was now clearly recognized under a treaty to which they were a party. It also formed the basis for the subsequent judgment of the European Court of Human Rights in the case of Bayatian versus Armenia, where WRI, CUNO, Amnesty International, and CPTI submitted an amicus curiae brief, a friend of the court, a third-party intervention, which, amongst other things, presented to the European Court the case law of the Human Rights Committee, including this groundbreaking decision. And that led the European Court to actually reverse its previous tendency to refuse to accept that this was part of the European Convention and protected under it, and it followed the decision of the Human Rights Committee in saying this was protected under the European Convention on Human Rights. And for European countries, this is important because the judgments of the European Court are binding on states in the Council of Europe. Again, that doesn't necessarily mean that all states, although Armenia in fact did implement and has recognized conscientious objection, it doesn't necessarily mean, unfortunately, that all European states have, or that they follow the judgments of the court in the way that they should. But that again is part of the follow-up process that is required. Thank you very much.